Good afternoon. It's a pleasure to welcome you all to the online webinar hosted by Educentric LLP. I'm Nalini Chandrakar and I'll be your moderator for today's seminar. So let's begin with our today's seminar, which is on career opportunities in corporate law. The economy and society in the past 2 decades has enabled enormous diversification in the legal profession and has opened a range of opportunities for students studying law. Last 2 decades have seen enormous diversification of the legal profession. Corporate law is one of the most popular law specialization that is opted by aspirants these days. Law graduates these days prefer to opt a career in corporate law and rather than going for a mainstream litigation. This leads them to pursue a diverse range of options and opportunities, such as working of corporate firms, think tanks, research institutions, working as in-house counsel in companies and corporations for both domestic and international. In simple words, law is forming, owing, operating, and managing the corporation. It is known to regulate directors, creditors, and other stakeholders community the environment interact with one another. Seminar is aimed at those who wish to dip their toe in the water of corporate work and obtain a taster of principles. And to address the above mentioned, we have our speaker, Ms. Ranjana Roy Gawai. Ms. Ranjana Roy Gawai is a founder and managing partner of RRG and Associates, a boutique law firm catering to high-stake and complex litigation of leading corporates in the country. She is a dynamic and multi-faced women entrepreneur, drive young and enthusiastic lawyers. Gawai is an expert in corporate litigation and advisory, especially in issues related to bankruptcy laws, shareholders' rights, mismanagement in companies, corporate governance, takeovers, acquisitions and securities and energy laws. She has also been successfully handling various domestic and international arbitrations, including ICC, SIAC, and LCIA. She's completed her law school journey from Delhi University. Previously, she worked with Ministry of Corporate Affairs, Government of India. She also worked as an associate with Anand from 2000 to 2001. She was partner with UKCA Law Chambers from 2003 to 2008 and with Dheer and Dheer Associates from 2008 till February 2010. She has been involved in various landmark corporate litigations and has extensive work experience wherein she has argued cases under diverse legislations such as Companies Act, insolvency laws, security laws, electricity laws, and mining laws. I please welcome Ms. Ranjana Roy Gawai to address the participants now.
Welcome to all. And first of all, let me just compliment the organizer. It's really a wonderful initiative created by this platform. And I understand that this has been created by young lawyers. It's a welcome move by all of you young lawyers who have thought about it and taking it forward and to educate all the young lawyers and aspirants in this area of law. So, friends, that reminds me of George Bernard Shaw, whose saying is that economy is art of making most of the life, and the love for economy is root of all virtue. And since corporate and commercial law is relating to economy of our country and economy of the world as a whole, therefore this is the most important aspect of the law, because this is where we create wealth. This is where we ensure that the compliance of the law is done in a proper manner. And while we promote the creation of wealth, at the same time, by this law, we ensure that every one of us comply with the law. So this is this platform, whoever has created, I must compliment and thank you all to giving me an opportunity to address all of you. And now, friends, I understand that I have to share my experiences as a corporate lawyer with all of you. I don't think so it's very much required because the moderator has already given the background. However, let me just give you a little bit of, the journey about myself, so as to just to instill, some sort of interest and also some sort of, the guidance, so that you can if you wish to follow it up and create little mark for yourself. Friends, as a young student, way back in 1993, I came from Bihar as a civil servant aspirant, because for all Biharis, it's not there are not very many career options. The reason for that is that universities and colleges are such way, and the parental pressure is also such that you have to actually create something for yourself as a career, but whatever are available in that background, you have to choose one. And obviously civil servant means you will be doing something creative for the society. You'll ensure that as an administrator, what are the developments you can do. So obviously, if you do not have a much exposure, this is very interesting area, and that is the reason that I came here in Delhi just immediately after my graduation. And we belong to a middle class, service class, well-educated family where we have got a education, but we don't have much money to splurge or spend here in Delhi to ensure that we all get education. After coming here, I started preparing for civil services, but at the same time, you go out and you see the exposure, you keep meeting people, and to meet my expenses, I started teaching young students, whereby it will not only enhance my knowledge, but at the same time, it will also ensure that, I get some money in hand to ensure that my education is done. But after a bit of exposure, I realized that law is really, really very, very interesting field. And I started exploring. I started go out speaking with, important lawyers in the area, young, middle-aged, or those who are senior advocates. I started discussing with them, and then I realized, oh, this is, in fact, very interesting area. Why it is interesting? Because every time you have to apply your mind to find a solution for your client, and also it's very intellectually stimulating. So that was the reason that I started, I started getting attracted towards law, and this is how then after long gap, I took admission in 97. I passed out in 2000, and I was already 29. So I had to really run faster than rest of them, because we have to make a mark to for ourselves. And finally, at a very young age, I realized that the habit of working hard is very, very important. And fortunately, as a lawyer, I got a break in a very big law firm, which was Anand and Anand. But I was just small participants in such a big house, and it was that time also it was very big, more than 50 lawyers working over there, and I felt completely lost over there. Not only that, though it was money wise, it was all right, but exposure wise, it's a very, very limited area. And I realized that actually I don't want to do this. I want to do something else which is stimulating on a daily basis. And there is a challenges every day. And then, I joined Mr. UK Chaudhary, senior advocate, who's a very well-known corporate lawyer in the country, senior advocate, Dr. UK Chaudhary. And under his wings, I worked there for 7 years without, really getting for day, night, morning, evening, worked very, very hard, gained all experiences, whatever I could have done under him. We used to get a lot of bashing. We used to get a lot of, at times he would say something which was very hurting, but on rethinking, we always used to realize, all right, so since we've not reached to that stage, and that's the expectation of our senior, that we have to reach there, and therefore, we have to work much harder than what we do. Presuming in ourselves that, oh, we are doing an excellent job, we are working so hard, but that was not enough. And in law, it's never enough. There is always a scope of learning. And after 7 years working hard, then I realized that, all right, I have to start my own journey. I started this new initiative, created law firm. And finally, this is where we are. And this area, especially the corporate and commercial law, according to me, is very, very interesting. Every day, it's not a set pattern like rest of the laws, be it a criminal, be it IPR, be it normal civil laws. It's very interesting because the area is extremely vast. It's not only a Companies Act, it's not only IBC. There are many other areas you have to know about. Securities Exchange Board of India, FEMA, FERA, FCRA, I mean, you name it, and then there are plethora of it. Just quickly go back to the topic of the day. Is the impact of IBC on a corporate and a commercial law. Well, friends, it's very interesting. It's a very interesting area. See, I mean, what is the need to create this law after a long gap, after 70 years of our independence, especially when just 2 years back, economy was doing excellent? Well, I'll just give you the background. What is the reason for bringing this new law? Well, this, IBC, we had a very traditional kind of a law. I would start with a CPC, which was enacted in 1908, where typical way of recovering money, typical way of taking control, was only through CPC. Civil Procedure Code, where you can go for recovery, you can go for injunction, you can go for appointment of receiver, then you can go for the breach of contract and all of that. And then that used to take a number of years for reaching to the right conclusion. Even creating a decree, passing the decree, it would normal time frame at that point in time was almost around 15 to 20 years, which was a long gap. And therefore, there was no recovery. So what happens is your investment is completely stuck in the system. So what is the way out? Then immediately thereafter, there was another two enactments in 1909. That was a Presidential Insolvency Act. And then there was a Provincial Insolvency Act in 1920. Well, in spite of having all that, I don't think very many people were aware of it. Also, very few. I've not seen much of a judgments in those area of law. There are very, very few areas of judgments, and that too, it was during the Privy Council. It was there, and then came 1956 Companies Act, where there was a provision of winding up. Through the winding up process, if someone is not paying your debt or someone is acting unfairly, if you are a stakeholder, then you can go to the court, and then you can actually ask for a winding of the company in case the company is not in a position to pay its debt. Then and then the winding up court also took its own sweet time, not before 10-15 years. I mean, that was the regular. High Court had jurisdiction, and that was the regular time frame for resolution of the company. So then after mid-80s, the need was felt that we have to ensure that the economy of country is ongoing. At the same time, whosoever is the stakeholder, especially the banks or the creditors, be it a secured creditor, unsecured creditor, or the operational creditor, they also need to be paid back, because unless you plow back the money into the system, economy will not grow, and your investment is completely stuck. So for that purposes, then there was an enactment of SICA, Sikh Industrial Act, and that enactment came in 1885. That was also not very pleasant move. People, the promoters, as usual, they would ensure that after taking benefit of Sikh company registration, they would take their own sweet time to ensure that the restructuring is taken place or company is finally restructured. If not restructured, then there was no mechanism in place with Sikh Industrial Board, where it could be wound up, and thereafter it would send back to High Court for winding up proceedings. So these were again very time-taking. Then ultimately, the bankers' money, it was realized that that's a bad debt, and it is not. The bankers are not able to recover. So then they came out with a concept of Debt Recovery Tribunal, and then the law was enacted, RDBBI Act, and that was also not very, I mean, though there was an increase in recovery, there was an increase in ensuring that the money comes back into the system, but that was also not very effective. From 4% of the recovery, it went to 11-12%. Then finally, Sarfasi Act came in 2002. After a lot of fight, finally it was settled, and DRT was given the power to ensure that you know the law is suit is filed and the recovery is done, but that was also not very effective. It would not be over before 5 to 10 years. Then finally, since investment of all bankers and the operational creditors were completely stuck, then there was an amendment in Companies Act 2013, and 2016 IBC came into play. And this is the a background of bringing this act into place. So friends, let us understand what is the objective of IBC. The objective of IBC is whatever is the existing legal framework that has to be created by one mechanism under the one act, and by one semi-judicial court, it should be adjudicated upon. And 2016 IBC came into play, which barred most of the acts where you cannot go, like you cannot file the suit, you cannot go to the company court, because binding provisions from the Companies Act was taken out and it was transferred back under the IBC. So this is that background. So friends, what is the objective? 4 objective according to me: the maximization of the assets which are stuck for a long time. Then second is to promote entrepreneurship. Third is the availability of credits, and fourth is the balance of interest of all stakeholders. So that's the background of this topic. What is the topic? Impact of IBC on litigation. Well, so it was ensured that litigation at the time of litigation is short, and the maximization of asset is availed. At the same time, all stakeholders can be balanced, and for that, the time frame, because that is the reason I gave you the background. In the background, why the investment was stuck for a long time, in spite of the fact that there were very many enactments. But under the IBC, the time frame is given. The maximum time given is 180 days. There can be extension of another 90 days one time. If there are litigation whereby court cannot resolve it in 180 days plus 90 days, then the maximum time period of 330 days has to be given. So the time frame is given. Like, it should not be beyond a year. That the resolution of to be ensured that it has to be done within a year. If not, then let the company go for liquidation, so that whatever money you have, let that pull it out from the company, and then, or the person, and then plow back into the economy. This is what the scheme of IBC is. Then if suppose the company is there, how will you ensure that the promoters cannot create any problems? For that, the day your petition is admitted, there is a provision for interim resolution professional who will act as CEO of the company. He'll take all decisions, and that decision has to be brought back to the COC. COC is the Constitution of Creditors. The Constitution of Creditors generally, in the case of a financial creditor, will be a financial creditor. But in case where there are certain cases where there are no financial creditors, only operational creditors, then in that case, since there is no financial creditors, operational creditors can form the constitution of committee. And then the whole mechanism is given. For that, there is a regulation provided under the IBC. And within 330 days, you have to ensure that the resolution is taken place. If it is not possible, then obviously the company will go into the winding up. These are the very, very important aspects which we have to, that has been, I'll tell you the success of it. The success is that from 22% of the recovery after all those enactments, I told you the history, then it has been increased to 46% in 4 years' time. So that's a very, very welcome move. However, during COVID time, what has happened is now there is amendments, there are ordinances under which during the COVID time, there is a default because see, I'm sure all of you, if any one of you who done IBC or reading, is one of the courses IBC. For the purpose of invoking IBC, what is the criteria? So criteria is very, very important, and that criteria over the period of time has changed. In 2016, it was 1 lakh debt. Debt has to be there in existence, then the debt has to be admitted, and then there is a default. So those three things are very, very important for invocation. And so therefore, how to do it, how to ensure, because this is a force majeure case. COVID-19 is a pandemic, which is a kind of force majeure where you cannot force people to pay because this is beyond anyone's hand. And for that purpose is to ensure that the ground of default during the COVID cannot be the default. It has been excluded. And this ordinance is till the time this COVID is there. So that is one aspect. And because what had happened was after this IBC came into play, small scale industries and mid-sized industries, there was no resolution, and companies started getting into liquidation. So to ensure that mid-run company and SMEs should not be completely wiped out, and those, because they are very, very important part of our economy. So to ensure that they carry on their businesses, there are further enactments in the Act, and there are and in that enactment, in that amendments, the promoters of small scale industries will participate. They can also restructure their debt. They can also become the resolution applicant. So these are the changes brought about. Now, after timeline, friends, I just wanted to tell you that law after 2016, since it's a time-bound process, the law has actually settled down in most of the cases, and starting from innovative, that what are the role of adjudicating authority, what is the role of RP, what is the power of COC, what is the power of other stakeholders. Everything has been decided. And 29A, which was the section which was introduced subsequent to notification of IBC in June 2016. This further amendment came in November 2016, whereby the defaulting promoters were completely barred from participating as a resolution applicant. Now, the question arises, why should they be barred? All right, so all of you can go and read the judgment Swiss Reborn. Very important judgment, Justice Nariman's judgment, a beautiful piece of laying down the law. I request all of you, that's a must read if you really want to understand what is that IBC all about. And subsequent to Swiss Reborn, there was another judgment of SR Steel that has reaffirmed its view, what was stated in Swiss Reborn. Again, a very, very interesting read, and excellent language, complete expression of the development of law, and then, analogy drawn as to what are the laws all across the world and why this law is very unique in itself and why it has been created for the purpose of saving the economy. So please, friends, read that another judgment also. It's a very, very important judgment, and you'll come to know that what are the powers and why the promoters are prevented. That's a punitive action brought in under the Act. Those who are the defaulting promoters, they cannot be. That's a matter of punishment. They have to be out because they were the ones who were not able to revive the company. They were not able to take the company out of NPA. So the person who has created an NPA, and within 1 year, if the person is not able to actually revive the company, that person has no right. So that bar was created by 29A and finally uphold in that Swiss Reborn judgment. So these are important aspects insofar as this area of law is concerned. Now, very, very important point which I don't want to miss, home buyer situation. See what had happened in between 2000 to 2020. There was a boom in realty sector. And that boom actually was in favor of only the realtors and not in favor of those who were the home buyers or flat buyers or who would make the investment. So the question arises, all right, if the company is going into IBC, what will happen to home buyers? What are the way out for that? So then finally there was um, amendments under the act, and the home buyers were brought in to the level of financial creditor. So that's very, very important development. And in that, on that basis, the right to the home buyers are also given. They can put their point of view across, and if it's only the realty company which is actually constructing the flats or the houses, so it will be home buyers who will become the decision maker in that case, because they are the financial creditors. So this is another very, very important aspect.
We know that National Company Law Tribunal is a specialized tribunal constituted for the purpose of speedier and effective regulation of the affairs of company. So in that aspect, can you please tell us what exactly is the role of NCLT and its role
Yes.
as an adjudicator?
Yeah, I'll just tell you, in my previous topic, I pointed out that there was an amendment under the Companies Act from 1956, though it was only a referral. I did not go deeper into it. So in 2013, there was an amendment under the Companies Act, because earlier the Companies Act was a very, very long. There were very many sections. It was one of the very bulky act. So it was realized that let us simplify it. In 2013, there was an amendment under the Companies Act which came into being, notified in fact in September 2013. There a special court was created, a tribunal was created, giving the special power where if any dispute relating to the company or any shares of the company, it will be only the company court. Sorry, it will be only the NCLT. Prior to NCLT, it was a company law board will have all the powers to hear that. And finally, NCLT came into being in 2015. Since the power to adjudicate upon the issues relating to company was given to the president of NCLT under the Companies Act, and there is a whole mechanism in place. So after this IBC coming into force, the same tribunal was actually given power to adjudicate upon the issues relating to insolvency and bankruptcy court, because there is a common area. Common area is that most of the companies, if you see the persons, a person has been defined under the IBC, which says the company or corporate persons or legal entities. So therefore, by way of notification, NCLT was given a power to act as an adjudicating authority under the IBC. And power of NCLT is power of adjudicating authority, who will be the same person, the president of NCLT, who will deal with 12 jurisdictions. One will be the law relating to companies, all the issues relating to companies. It will have a power and jurisdiction to decide upon. The same president will be renamed as adjudicating authority, and then he will be trying on the issues relating to IBC. Power of NCLT is described under the IBC, and the law in this area is very much settled. Same judgments. If you start with innovative and then go to Swiss Ribbon, Ramakrishna, and finally SR. So all those judgments will tell you that what are the powers. Well, so the question arises is, if NCLT is there, then how one can say that creditors of committee will have all the powers? Yes, creditors of committee has got a power, because it says that the majority of a creditors of committee by 66% of a vote can pass any resolution, including the approval of the resolution plan, including the rejection of the resolution plan. But that power is not unfettered. The power has got some sort of restrictions. And who will then put the restrictions? It will be the adjudicating authority who will who will ensure that the COC is not taking a decision which is completely in its favor, the majority's favor. It has to be on the ground of fairness. And what is the fairness? Suppose the 66% majority vote is passing the resolution plan, and as per the act, it is binding on all parties. Then what will happen to those who are separate class, for example, operational creditor, because they do not constitute part of the creditors committee. So what will happen to that? So there the role of NCLT is very, very important. It has to be on a proportion basis. What will happen to the employees? And that also is provided under act. And then the court has to see, adjudicating authority has to see whether the power, whether the resolution plan which has been passed is based on fairness, is based on principles of a natural justice. And also third, very, very important point is that there is no infraction of any law prevalent at this point in time in our country. So these are the important aspects. I mean, sometimes it may be fair, but it may be contrary to law. So who will see that? I mean, obviously the creditors committee is not expert in ensuring that the law is complied with, though there is a duty cast upon RP, the resolution professional, who has to appoint its legal counsel, who will give them the advice to ensure that all the laws are complied with. However, whether the law has been correctly complied with or not, there the power of adjudicating authority comes into play. So these are the important role of adjudicating authority under IBC.
An ongoing conflict between NCLT and SEBI. Can you please share your views on that?
Yes. So I'll just give you a quick background that what is the area of a conflict? What are the jurisdiction and where the clash comes, and how to then harmoniously construct, the area where if one takes the decision, whether it is correct decision and whether it is binding, and can adjudicating authority then take that particular decision in its hand to ensure that the IBC is the provision of IBC comes into play. For that, it's very, very important to understand the jurisdiction of both the courts. So SEBI has got a power to ensure that the investors' interests are protected. How the investors' interest will be protected? Because SEBI's role comes into play, or SEBI's jurisdiction comes into play relating to the companies which are listed companies, listed on the stock exchanges. So, and therefore who is the monitoring agency for stock exchanges? It's a SEBI, Securities Exchange Board of India, is the agency, the monitoring agency, which will ensure that everything is complied with. And for that, there is a whole lot of compliance requirement that is provided in the SEBI Act. So what happens is the small investors, they have invested their money into the company, and that small investors' money cannot be stuck forever. There has to be some room for them to ensure that their money is given back, maybe with some profit, maybe sometimes loss, but it should be complete prerogative of the investors, and that can be possible only when the promoters act in a proper and a genuine manner. So this is where the SEBI role comes. If suppose there is a non-compliance by the promoters, there is a non-compliance by the stock exchanges, and the promoters are indulging into the insider tradings, who will detect? How will detect? So therefore, as and when the investor, the aggrieved investor, writes to the stock exchange, and if the stock exchange takes the the requisite decision to ensure that the compliance is done, and if the compliance is not done, what are the punishments, what are the ban, whether it can be done or not, and if the stock exchanges also doesn't take care of it, the company finally is given to SEBI. So SEBI otherwise also has got a power to do search from time to time, take the custody of all the books of accounts and records to ensure that the compliance of the law is done, there is no hanky-panky. And for that purpose, it comes to know that no, there is an infraction of law. They have done it to they've taken some action by which they are only the gainers. I mean, promoters are only the gainers, and the small investors are at the receiving end. Therefore, SEBI will then come out with a gag order. Sometimes they are completely banned from accessing the market. Sometimes there will be adjudication, there will be fine goes up till 10 to 15 crores, and sometimes equivalent amount of fraud. So these are the areas which are very, very important. How to recover the penalty which has been imposed. So what happens is that they have got a power and a right to attach the property, and after the time frame, if the promoters or whosoever is the person who's involved in the fraud are not able to repay that, the attached property will be sold off. Now, so therefore, that's one aspect. In the meantime, some of the creditors whose payment is due and it has been admitted and it has been not paid, what happens goes to the IBC company. Now, the question arises is whether IBC can be kicked in that kind of situation. So there are two views right now. It's a very, very nascent area of law. It has not yet been settled, but I know for sure because we are involved in that matter. There is a matter in the name of Bhanuram versus HBN Dairies. Bhanuram versus HBN Dairies and Allied Limited is actually a listed company where there was some action by SEBI, where what had happened was the investors had paid to the company by way of fixed deposits, which was to be returned in a particular time, but that was not done. So SEBI was taking action. There was some sort of properties attached. In the meantime, the person Bhanuram also came into IBC, and then there was an admission of the matter, but then the matter was again taken in appeal by the company. They said that, look, once SEBI is already investigating upon the issue, so how they will have no power, because both of them are specialized law. But all of us has to be mindful of the fact that IBC is a subsequent law. There is a non-substantive laws which says that this law will have a precedence over all other laws. So that was the area of dispute. Finally, matter went to Supreme Court. Supreme Court has said that, all right, let the RPB continue to take the control of the company and run the company. However, the property which has been attached will not be dealt with by RP till Supreme Court decides that matter. So that law has not yet been settled. Based on that, there is a subsequent recent matter which is also being handled by our office. Krishna Kumar Sahu and 7 others versus Sai Prasad Properties Limited. There again, the same situation where SEBI has attached some part of the properties of the company, and simultaneously IBC was invoked, but then Bombay NCLT, Bombay bench, NCLT has come to the conclusion that since SEBI has already initiated the process, it will not have a meaningful resolution because part of the properties are attached, though the matter is under consideration for NCLT. So the law has not yet been settled, but prima facie, my view is that IBC will have a precedence and prevalence, because the penalty will also be part of the operational creditor. Because penalty is what? It's a payable. It's a payable to whom? It's a payable to small investors through SEBI. So therefore, according to me, I have no doubt in my mind that IBC will have a prevalence. And but obviously, I'm not a judge. I cannot write the judgment, but I'm sure the matter will be decided soon on this aspect.
Okay, ma'am. So as we know that every industry has been hit hard by the ongoing pandemic in today's time due to coronavirus. So what steps are being taken by the corporate sector to mitigate the impact of lockdown as of now?
I must compliment the government, because government has taken very many measures. First of all, there are steps taken with respect to companies. And now what has happened is the threshold for invoking the IBC has been tremendously increased, and that threshold from one which was in 2016 June when it had come into effect, it was 1 lakh of rupees. If any person who's got a debt due and admitted over and above 1 lakh of rupees can go to the tribunal, NCLT, and can file for the restructuring. However, after this COVID situation, that amount has been increased from 1 lakh to 1 crore. So that's the one step relating to this IBC. And also, you cannot ask for the restructuring if you do not have a debt due and payable and admitted up to 1 crore of rupees. Then there is a subsequent amendments whereby it says that if there is a default occurred during this COVID period, this would be treated as force majeure, and therefore the debt due during COVID cannot be the ground for invocation of IBC. That's the another amendment insofar as IBC is concerned. Then under the Companies Act, there are various relaxations, and also for LLPs under the Companies Act and IBC for the purpose of compliance requirements. So that step has also been taken. Third is under the income tax. Vivad Ka Vishwas, there is a scheme where even if there is an amount due and payable, but if that dispute is in existence, you can go and get that is called amnesty scheme under the IT Act. So you can go and get your you can invoke that scheme, and you can get that one-time solution for your amount due and payable.
Right.
And then in all other areas of law, like in criminal law, you must have heard that during COVID situation, a person can get interim bail for 45 days. So these are the actions taken. I think there are also the further enactments in under SEBI law and under banking norms, where banking also gives you extends the moratorium, and they will not charge the interest component. That moratorium is extended for 3 months initially, and then again it has been extended for another 3 months. So these are the enactments during the COVID time.
Right. So, ma'am, now we'll open the forum for the questions, and we have few questions by the participants.
Yeah.
The first question we have is, what qualities a student should acquire during his college to become more resourceful to a prospective employer, as in when he's entering to his journey of internships and working with the law firm? So, what desired things he should have?
That's very important questions and very pertinent question also. I'll tell you what happens is people whosoever takes the law course, they think that after 5 years they'll come out and they'll in one day they'll become Fali Nariman, they'll become Soli Sorabji. That's not the case. To become Fali Nariman, to become Soli Sorabji, one has to be very, very keen to learn. So learning is important process. But what happens is normally, okay, 5 years, what is that break I will get? What is the amount I will get as my first salary? So that should not be there, because see, money will follow if you acquire the acumen, if you acquire the knowledge and law. So wherever you go for internship, ensure that it should not be bookish. Whatever small problem you face, you have to apply your mind. Please apply your mind, do hard work, go to every smallest part of the organization, including office boy, peon, then court master, your clerk. Ask them what is the process of a filing, what is the process of a writing. Go even to the accountant, because that's also very important. If you are going to the accountant, he will tell you, because you are doing the work, but this is a profession, so that has to be compensated by money. So billing is another important aspect, and research is third important aspect. You should try, suppose you're in the first year, try doing good research, try finding out important proposition of law, and it should not be only just go to Manu Patra and SEC online, just put that number. That's not the good way of doing the research. What you can do is, yes, that will save your time to get you the citation. Take the citation, but try reading the book. Try reading the act. Try reading AIR manual. That will tell you how the law has been developed over the period of time. If you do not get requisite material, then go back to All England Reporter, you go back to Chancery Division, you go back to another book, but read the book. But merely reading the book is not enough. You have to implement it. You have to apply it in the given situation. The case which you are handling is very important. And I'll tell you, Delhi University has got a very interesting way of teaching. So what happens is Delhi University will give you the case laws. You read the case law. That's all, and then there will be the what is the case, then what are the laws involved, what are the interpretation of law, and how that one law versus second law, how it can be harmoniously construed, what is the real reason. So these are the important aspects one should look for. Initial 3 years, that's very, very important.
All right. Ma'am, the second question we have is, if a student starts the internship in a corporate firms for, say, second year, so what should be the first target? As in, start with the district forums, or we should start with the corporate law firms directly, or with a lawyer?
I see it's an individual perspective. It's a completely individual perspective. What do you want to do? If you want to become a litigating lawyer, I mean, starting you can start from anywhere. If you have, yes, but if you want to become a criminal lawyer, go to the district courts, where you will get the exposure of doing your cross examination. You learn the cross examination. You'll also learn the trial. So those are important. But if you really want to become a good corporate lawyer, I think a boutique law firm will be the ground to start with. And then once you acquire your expertise, then you can go wherever. You can go to big law firm, you can go to in-house. So it depends, what kind of interest you have. Some people I have seen, they are very interested in a corporate advisory law. That's also a very, very interesting area, because corporate advisory law, you will draft the agreements, you will draft the, you'll draw the all sorts of contracts, and very complex contracts, which are very, very technical. For that, you have to read the technical aspects of it. For example, the power plant, how the power plant is created. For that, what kind of a contract is required for that, what are the laws in that area. So for that, you'll have to really go and speak with the person who may be an engineer. You have to ask how it is operated upon. And then what are the laws relevant, like for the power plant, there has to be compliance of the environmental law, there has to be compliance of electricity law, then land acquisition law. I mean, you name it and it's there. So
Right.
so therefore you have to then dissect that what are the, and also the labor laws. So advisory work is also very, very important, provided you have that acumen. So my advice to all young lawyers would be to acquire the acumen as much as possible in initial 3 years. Don't run after the money. Try acquiring the expertise, and people will then come and take you.
Right. So, ma'am, the next question we have here is, how practically viable it is for NCLT to abide by the timelines prescribed by the law? As in, whatever it is said in the rule book, is it really practicable, or what difficulties are faced by?
Yes, that's a interesting question. I'll tell you, like big 12 defaulters in the beginning, because of which the IBC came into picture, and because of the notification, one day all big 12 companies who had taken maximum 2 lakhs crore of loans from various big companies, that was admitted before NCLT. Out of that, uh, 2 of the matters were criticized for taking longer than what was the time frame required. So then court took its, the convenient view. All right, so whatever is the time which has been lost for litigation, that should be excluded while computing the time frame, because time frame is 180 days and an extension of 90 days, right? So SR took more than 440 days. Bhushan Power took more than 440 days. Since it took more than 440 days in completing the resolution, then there is a further enactment in the section. And now the time frame given is 330 days, including the including the litigation period. Otherwise, small matters have been resolved in 180 days, except that this COVID period. The success rate is pretty
All
high.
right. Okay. So, ma'am, the next question we have is, does the law improve the balance between the rights of creditors and the firm debtors during insolvency?
Sorry, I didn't get your questions right.
Ma'am, the question is, does the law improve the balance between rights of the creditors and the firm debtors during insolvency? Or is it like there's the imbalance or something
No,
like we need to manage it?
there is no imbalance except that mental imbalances. Because the promoters think that whatever money it has, taken from the banks or those who are the stakeholders like operational creditors, they are also contributing towards the growth. And they feel that no, it's all that since company is mine, therefore everything is mine, and I'll play as per my whims and fancies. That is not correct. And therefore, this law ensures, I told you there are four objectives under this law.
Hmm.
And one of the objective is to ensure the balance for all stakeholders.
Okay. Ma'am, the next question we have is, what is the role played by the NCLT as visualized within the IBC?
I think I have already explained this in a greater details under the topic. However, at the cost of repetition, I'm just telling you the role of adjudicating authorities very, very important because they are the watchdogs. They are the ones who ensure that there is a compliance of law and compliance of law in true letter and spirit.
Okay. So, ma'am, can NCLT question the commercial wisdom of the committee of creditors?
Not commercial wisdom of committee of creditors. That's very well defined. Commercial, but the commercial wisdom of the creditors has not to be unfair to another creditors, be it operational creditor or the employees or the government dues. That has to be proportionate. That is where the role of adjudicating authority is important.
Okay. There's a request by Rashmi that can you please repeat the relevant case laws which you mentioned earlier in the respect of understanding IBC?
Yes, starting from Innoventive.
Yes,
Innoventive
ma'am.
is very, very important judgment, which talks about that what are the rights and rights of operational creditor, and what is the manner in which IBC can be invoked, and what are the role of adjudicating authority. It's just a rubber stamp, or it has to apply mine. Whether the defense taken by the other side is just a defense like moonshine, or the court can go into real intent, whether the defense is uh, plausible defense, then only it will reject um, the petition, otherwise it will be admitted. So that's innovative judgment. Second judgment, which is very, very important, relating to personal guarantors, because that's another issue. People think, oh, my company is gone, why should my guarantees also be taken away from me? I mean, personal guarantee my personal assets. For that, there is SBI versus Ramakrishna. Then third judgment, which is very important, is Swiss Reborn. You can see that. Then fourth judgment is SR judgment, all Supreme Court.
Okay. Ma'am, we have a question by Rutika that
Yeah,
what kind of
one more judgment you can add. I'm sorry I missed that. That's ArcelorMittal's judgment. ArcelorMittal versus Satish Kumar Gupta.
okay. Ma'am, we have one last question by Rutika that what kind of work environment is there in a corporate firm and how different it is when you work in a litigation firm?
Well, environment is pretty good because see, ultimately it's a professional organization, and people, those who want to run it very professionally, which is the the case, because it's very competitive, because the clients are common. Most of the clients have limited number of clients, but the number of lawyers are too many. So therefore, it's very competitive. So people make their offices very, very professional. And firms these days, I have seen, like it may not be prevalent in a smaller firms, but in a boutique firms, in a good firms, there is a zero tolerance for sexual harassment. There is a good working environment. There is a good security environment. There are very many law firms where the female employees are working, female lawyers are working for that. There is a creche if there is a small child, to ensure that the person works with all ease.
Right. So, thank you, ma'am. Thank you so much. This was really great to have you. It was a very informative and knowledgeable seminar. Thank you, ma'am. Thank you so much.
You.